Thank you. Please be seated. Good morning. Welcome to this special session of the Supreme Court of the State of Kansas in the beautiful Sharon K. Dean Recital Hall in McRae Hall on the campus of Pittsburg State University. For the first 150 years of the existence of the Supreme Court of Kansas, the court sat in its courtroom in Topeka to hear cases. And in 2011, my colleagues and I decided that we would try to make our court more accessible to the people of Kansas, the approximately 3 million people that we serve. And so we began to make trips outside of our courtroom. We have been to Salina to hear oral arguments on cases. We've been to Greensburg in southeast Kansas. We've been to Wichita in south central Kansas, Johnson County on our eastern border, and now here in Pittsburgh. I've told you why we're here. Let me briefly tell you who is here with me. I'm going to briefly introduce the colleagues of mine on the Kansas Supreme Court, and I'll start in seniority. To my right is the Honorable Marla Lukert. She came to the Kansas Supreme Court from the 3rd Judicial District in Topeka, Shawnee County, where she served as the Chief Judge. To my immediate left, the Honorable Carol Byer, who came to us from the Kansas Court of Appeals. Before that, she practiced law in Wichita. To my next right, next to Justice Lukert, is the Honorable Eric Rosen. Like Justice Lukert, he too sat on the district court bench in Shawnee County before he came to us. To my left next is the Honorable Lee Johnson. Like Justice Byer, he came to us from the Kansas Court of Appeals. Before that, he practiced law in south central Kansas in a town called Caldwell. To my far right is the Honorable Dan Biles, who came to us directly from the practice of law in Johnson County, Kansas. And if you've looked at your brochures for the court, you'll know that our 7th colleague, the Honorable Nancy Moritz, is not here today, but the sitting in for her today is the Honorable Dan Kreitz, who is the Chief Judge of the 31st Judicial District. He sits in Iola, not too far from here. Judge Kreitz has read all the parties' briefs, like all of his colleagues. He will be fully participating in the oral arguments today and also in our case conference this afternoon and tomorrow and in the ultimate resolution of these cases. Judge Kreitz, on behalf of my colleagues, I want to thank you for helping out the Supreme Court.
Thank you.
Of course, an activity like today requires the hard work of an awful lot of people for us to be able to travel from our courtroom in Topeka. I'm speaking, of course, of our staff, but also a lot of people here at Pittsburg State University. I can't possibly thank everybody from Pittsburg State, so I'm simply going to say a thank you to the president, Dr. Steve Scott, and his wisdom in hiring so many hardworking, dedicated people to help us out. Staff, faculty, and administrators alike. So far, from our vantage point, everything has gone flawlessly. I also did want to recognize law enforcement's assistance. If you look around this room, you see a lot of people in uniform, some not in uniform, and these represent various law enforcement agencies from the Crawford County area. I want to thank them as well for their hard work. Lastly, I want to recognize our bailiff today. She, along with some other employees from the 11th Judicial District here in Crawford County, is assisting us. And she is the person who called you to attention when we came in. That is Pam Hicks. She is the clerk of the Crawford County District Court. She has served in that capacity since 1990, and she in fact has worked a total of 27 years for the Kansas Judicial Branch. An awful lot of people in the auditorium today. I'm not going to ask everybody to stand and tell us who you are. We'd be here all day. But I did want to recognize a few groups that have been brought to my attention. Starting this morning, we have people from the Frontenac High School, the Girard High School, the Humboldt High School, and the Pittsburgh High School. And I'm told joining us later this morning will be students from St. Mary's Colgan High School and also some students from the Philosophy of Law class of Professor Kathleen Cameron. and you may see other people wandering in and out. Presumably there'll be additional PSU students. We want to conclude by thanking you all for coming, because with your help, we are making history today. As you could tell from my earlier remarks, this is the first time the Supreme Court of Kansas has sat in Southeast Kansas. And with your help today, we'll make this a great session. With that, I will ask the clerk of the Kansas Supreme Court, Ms. Carol Green, to do the honor of calling this morning's docket. Ms. Green.
Appeal number 108,526, Craig and others versus FedEx Ground Package System Incorporated, moved by President
Steve Six.
Name the order for FedEx Ground Package System.
Appeal number 105,876, Sleep versus Sedan City Hospital and David Short, on petition for review, Chautauqua County, briefs both sides.
G. Thomas Phillips, attorney for the defendants, Thomas Sleeps.
Blake Hudson, attorney for Sedan City Hospital, here and ready to argue.
Appeal number 109,018, in the matter of the acquisition of property by eminent domain, Unified School District 356, Anderson County versus Diebold, Anderson County, briefs both sides.
Your Honor, appellants Donald and Susan Diebold, appeared by counsel Brett A. Hine.
Unified School District 365 by Lee Tetweiler. We're ready.
Appeal number 103,532, State of Kansas versus Holt, Bourbon County, briefs both sides.
Richard Bank from the appellant, Jared Holt, ready for argument.
May it please the court, Terry Johnson for the appellee, ready for
Thank you, Ms. Green. I now officially call the first case on this morning's docket. That is case number 108526, Carleen and Craig et al., the FedEx Ground Package System, Inc.
Good morning, and may it please the court. My name is Steve Six. I represent the plaintiff appellant FedEx drivers. Mr. Chief Justice, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
The question before the court is whether full-time pickup and delivery drivers for FedEx that perform FedEx's core business function, that are not hired to run independent businesses of their own, but work in FedEx's business, are employees under the expansive definition in the Kansas Wage Payment Act, or whether FedEx can misclassify these employees and avoid the wage protections in the Act through the use of an agreement that employs contractual labels, illusory rights, and conceits to mask the employment relationship, shifts the ordinary costs of its business onto the workers, uniforms, package scanners, receipts left at the door. The cost that FedEx shifts to these workers are through pay deductions that, but for the misclassification in the operating agreement, would be illegal under the Wage Payment Act.
Can you tell me specifically what kind of deductions you're talking about?
For example, the business support package. This is the package that drivers use to get the FedEx-specific equipment, like a FedEx-specific uniform, a scanner that can only be used for FedEx equipment, customer receipts that are left at the door when you're not home, DOT drug tests.
Which is
These are paid-
optional. Those are optional, and they agree to do that.
Exactly. They are optional in the sense that 99% of the drivers participate in the business support package. Comes out of their weekly settlement check. And
Is there anything in the Kansas Wage Payment Act that precludes an arrangement whereby the worker agrees to provide, say, the vehicle, or provide their own uniform, or provide their own equipment? For instance, if you hired someone to do a mechanic's job and part of the agreement is you bring your own tools. There's nothing in the statute that would preclude that arrangement, is there?
no, there isn't. And to suggest it's like the independent contractor building your fence that may show up with certain kinds of tools, and if you interviewed a second guy for a different estimate, he had a different set of tools. This is a business support package that comes out of the weekly paychecks that applies to all the drivers that 99% of them participate in, that includes shifting those costs, uniform, drug tests, scanners, onto the workers. And but for that operating agreement, those would be illegal. So the idea that it is like any other independent contractor, I don't think fits that model. The Seventh Circuit was properly concerned about this type of misclassification. Attached as Appendix A is the Seventh Circuit's opinion, and at page 8, it recognizes that employers like FedEx have a strong economic incentive to do what's done here, to misclassify workers, which is unfair to state agencies that lose revenue, workers who lose wage and injury protection, and it's unfair to FedEx's competitors who play by the rules in Kansas and use employees to deliver their packages. That's what the district court determined. So how do they do that? It's through these contractual labels and these conceits in the operating agreement that mask the constraints of the employment relationship. FedEx will get up here and tell you, well, it's not an employee relation, it's not an employee when you can hire others to do your work, or you can, sell your route. I mean, FedEx maintains as much control over all of these so-called opportunities as they need to. FedEx has the power to veto any temporary replacement or replacement driver, any route sale, to deny approval to any driver for additional routes. And, think about the sale here. So they're pitching to you that an independent contractor, like a siding contractor, builds up this business, and now they're going to sell it. FedEx maintains in the operating agreement the right to reconfigure the route. If you got a mall built in your route, you're thinking, great, I got all these new packages. FedEx can cut your route in half and assign that new part to a different driver. Now they say, well, there's a 5-day cure. If you told me today my route was being configured, that means I've got, a pretty short time to take care of that. So it's this type of suggestion that there's a real right, but under the operating agreement and the common documents, it doesn't exist.
Can I back you up to something rather fundamental, and that's the test that we should be applying? The Department of Labor in Kansas has a regulation that refers to the federal economic realities test, but this court has traditionally applied the right to control. Right to control is a component of the economic reality, but it's not the overarching determinant. So which do we apply?
This court has traditionally in decades applied the right to control test. There are many other indicia.
We wouldn't want reality to enter into the calculus under the economic reality. The seduction of the economic reality is let's look at what's in real life rather than to apply some kind of legalese.
Well, I think this court has described it as the right to control the manner and means of the employee's work. So you look at, are they simply taking care of, is the person just contracting for a result, or has the principal retained the control to manage how they do it? And the right to control test is informed by these other factors like, what's the skill level? Is there entrepreneurial opportunity? That's simply one of the factors and not the primary focus of the test.
Counsel, I'd like to ask an even more fundamental question, if I may, and that is this. It seems to me that regardless of which test you use, it's going to be a fact-driven outcome. It's always going to be, every case is going to be different from the next case, which will be different from the next case, et cetera. And that seems to me to be in conflict with the whole concept of answering a question of law for the Seventh Circuit. If what we're really doing is looking at the facts of this particular case and deciding how it comes out under one or the other tests, that really answering a question of law?
I think you're uniquely in a place to do that. What was the federal district court's assignment here? Sitting in diversity, they were to determine the facts, which the court has done, the district court, and put them in the opinion, and then pretend that they're all of you to decide whether these are employees or independent contractors. A court sitting in diversity is looking to predict what you guys were going to do with this set of facts, and I think you're in a unique position to actually tell us that. We think perhaps the district court looked at these facts and came to a conclusion based on this court's precedents and test that would be different.
And the district court felt this was a very close case. So what policy do we apply in such a situation or direct the Seventh Circuit to apply? Is there an overriding public policy that governs this?
In the Coma case, which involved the undocumented workers, and in the Campbell case, which was a Wage Payment Act case where a worker was bringing a retaliatory discharge claim, this court said that the Wage Payment Act is part of this broad group of remedial statutes that protect workers that Kansas has had for decades and decades. So the policy test comes from the reason behind these statutes. Think of the tort context where you're dealing with respondeat superior liability. That's designed to protect the employer, to limit the employer's reach for torts committed by somebody they have no control over. Under the worker protection statutes, you're looking at how can we protect workers' wages and workers from injury.
Protect employees. And broadly construing to affect the protection is different than broadly construing who is an employee, because you would agree that independent contractors are not subject to the KWPA, right?
Well, exactly. And
so my question is, it boils down to do we broadly construe the statute to be more inclusive of who's covered, not in the coverage that it provides. And the distinction is the workers' compensation specifically directs us to do that. Broadly construe so that workers are brought within the ambit. But the KWPA doesn't include that same language.
Well, I'd say two things on that. First, I think this case, if you look at the court's precedents and the control that is exercised virtually through every aspect of these drivers' day, you don't need to reach the public policy. You can decide it based on the right of control test. But there is a public policy embedded in the Act. And in this court's decision in the Pfeiffer versus FedEx case, which came out after the briefing here, you looked at whether a employee could bring a retaliatory discharge claim when FedEx shortened the contractual limitation for bringing the case, the statute of limitations. And you found that there was a wall built between the employees and their right to access the Act. And what do we have here but a private agreement that shifts the cost of FedEx's business onto the employees? But for that private agreement, those deductions would be illegal. So I think the policy should inform the court to cast a very skeptical eye on brilliantly drafted contracts that impose the constraints of an employment relationship in the guise of an independent contractor model. That is the type of review that I think has to happen. I mean, how can it be fair under the expansive definition of employee or the public policy this court has recognized if you have one group of drivers who have lawyers who have drafted an agreement like this, and another group that are doing exactly the same thing, and have it turn on whether or not this second group never gets the protection of the Wage Act because of a brilliantly drafted agreement like that. And FedEx recognizes that there's significant control here. They say the control doesn't come from us. It comes from government regulations, it comes from customer demands, and it comes from contracted for results. In the government regulations, there's some very moderate, minor safety regulations. We don't advance those as the reasons for the control, and FedEx's control goes far beyond those regulations.
So you have no quibble with whatever comes from regulation?
Right. I mean, that was addressed by the Estrada Court, the California Appeals Court that looked at this, same operating agreement, and found that FedEx's controls went way beyond. Same with the Wells case we provided in the supplemental authority. So customer demands, let's think about that. FedEx is saying all these details. I mean, they check, does the driver efficiently get out of the truck? Do they take the efficient route to the package delivery point? Do they follow every customer release? When the customer's not there, do they do this? Do the ground drivers call a FedEx manager to get permission to release the package? They call that customer demands. I mean, FedEx has millions of customers. They demand all kinds of things. And FedEx, like any business, synthesizes that down to what they want to do. They reject all kinds of demands that may not make business sense. The Seventh Circuit recognized that and said, on customer demands, of course it's FedEx that determines what services it provides and when. And the contracted for results, I mean, we're talking about the safe and efficient delivery of a package. FedEx controls through customer service ride-alongs. 4 times a year, they can ride along with employees all day long and evaluate if you look at page 13 of Appendix B of Appellant's brief, there's a list of these criteria. They can evaluate every intricate detail of how the package is delivered between the truck and the house, and also account for whether the driver enters back into the scanner, that's a unique FedEx scanner, the address of the next address before getting back in the truck. If they don't do that, that can be improperly following FedEx's policies and procedures, and it can lead to building a file that can lead to termination.
Counsel, you're well out of time. Would you like 30 seconds to wrap up?
Please, Mr. Chief Justice. So the case can be decided based on this court's right of control cases. In the Noble case, this court looked at a case involving truck drivers. There were some criteria that weighed toward employee, some criteria toward toward independent contractor, and the drivers signed an agreement that said they were independent contractors. This court looked at that and found that found that the employer had retained just as much control as they wanted or needed. I'll reserve the remainder of my time for rebuttal.
Do we have any further questions of counsel? Justice Johnson.
I have a quick one. With regard to the Seventh Circuit's second question, the class was certified, as I understand it, to include full-time drivers between, I think, 1998 and 2007. That would not include a multiple work area driver necessarily. What I'm after is, this is all focusing on someone that's a full-time driver and the facts that apply to that type of driver. So why isn't the second question asking for an advisory opinion?
Because there's almost no difference between the primary driver and the additional driver. The class is defined at Appendix A in the Seventh Circuit opinion, footnote 1, and it is people who full-time drive and may also have an additional route. So the control
but that wouldn't include the person that doesn't drive, may have 2 routes but hires for both.
Somebody who doesn't drive isn't in the class.
That's what I'm saying. So why wouldn't asking our opinion for that class of people or that particular circumstance an advisory opinion?
Because the second question relates to people that may full-time drive who also have another route. And the control is applied from FedEx down to both the primary and the additional driver. It's not like the control goes from FedEx to the primary driver and then I supervise the additional driver.
So you view the second question as asking us whether a full-time driver who may own another route is treated any differently? That's the question?
Yes.
Okay.
And just to follow up, it looked to me like both of you were arguing that the answer to the first question drives the answer to the second.
I think that's correct.
Okay, thanks.
Any more questions? Thank you, counsel.
May it please the court, I'm Jim Oliver, and it's my privilege to present the case for FedEx Ground Package System. On the undisputed factual record, the Seventh Circuit has asked this court to determine whether these plaintiff contractors are employees. They are not. First, no employee has the right never to show up for work or to buy or sell his work area, to own and control multiple work areas.
That's illusory. Their truck has to show up for work.
The truck, a truck has to service the route. That's our agreement to provide service to a service area.
But if that truck shows up out here in this street, it's got FedEx on it, the person getting out has FedEx clothes, correct?
That's correct.
And doesn't everybody assume that's a FedEx employee, a FedEx truck?
I don't know that everybody assumes that. I mean, they have the right and do carry their own business cards and can show up and say, I'm your contractor, I would like to have.
You argued that. You argued that part of the reason to make them wear a uniform is so that people will feel secure and open their businesses or their home to them. And the only reason that argument works is if the people are led to believe that these are FedEx employees.
I think it works the same if they're led to believe they're FedEx contractors. I mean, the point is, when someone shows up and asks for a package, it works different if they're showing up in a stocking cap and a Royals t-shirt and blue jeans than if they have the FedEx uniform. And that is a benefit to the contractor. But changing what color suit I wore today, or whether I wore brown shoes or black shoes, does not change the methods and means by which I do my work. And, you know, you can take, I think a lot of what plaintiffs do is strain at gnats and ask you to swallow a camel. That's why I started the argument the way I did. I mean, wearing a uniform is mutually beneficial. It identifies them to the person who is going to entrust a package as somebody who will put it in the FedEx ground system, but it does not make that contractor subject to any controls over means and methods.
Mr.
Yes.
Oliver, the operating agreement requires the drivers to make reasonable efforts to retain and increase the base of customers served and the number of packages that the customers use. How do they do that?
They do that by providing good customer service, by delivering packages timely and without damage, and by using their entrepreneurial abilities to recruit customers, encourage them to use them instead of a competitor.
Is there a measurement that's done of the number of customers that increase in a particular route, and do the drivers get more money because that customer base has been increased?
The drivers have a contractual right to deliver every package in their territory as long as they can reasonably do so. They do get paid primarily, as the district court found, by packages picked up and delivered and by number of stops made. So by increasing the number of packages, they bear the first economic benefit. If more economic development occurs in their territory, they have a right to serve it. They can do that by hiring helpers to help them deliver faster.
The right up until the point that the manager says that's too much and we're going to use the flex program and we're going to move. Any day that they show up, the new customers that they've developed can be given to another driver by the manager from FedEx, and that FedEx makes that decision.
They can only be given to another driver against that route owner's will if he can't reasonably serve it. And so when you're talking about
determination, the manager that's making that assignment makes that determination of how many the independent contractor, small businessman doesn't decide how many stops he or she could make. FedEx makes that determination, correct?
Well, may it please the court, I think that is done on an objective basis, that you have an obligation to deliver the packages, and if you're not getting it done, if you're coming back at the end of the day with 10 or 20 packages, you can't reasonably serve the route. And one of the things that I think the plaintiff's mistake continually in the argument is ignoring the implied covenant of good faith and fair dealing, which is a real deal in this state, and which the court found these rights and the way the people behave under them are substantial. They are not illusory rights or conceits. And so before somebody says they're not reasonably serving their territory, that means they're actually in breach of contract because they've got packages they've agreed to deliver that they can't or haven't delivered.
So the message to a contractor is grow your business, but don't grow it too much?
Well, you can grow it in a manner that you can handle. And you can arrange to, I mean, that's one of the benefits, for example, of buying another route. So you can have the ability to share that territory. You can always trade packages with other drivers and reconfigure your route voluntarily. You can, I think, by adding helpers, increase the efficiency of your delivery times. And every day is not the same. Every day you have to figure out how to load the packages, how to handle the route. That is if you drive. And you can elect to drive not at all or part-time. And so it is fundamentally, can I just tell you how this business started out? They started, RPS, Roadway Package System, in 1985. Had no drivers, no terminals, no nothing. And you're trying to start from scratch with the dream of being a national competitor against UPS and other established competitors. And so you have limited capital and you need everything. The decision was made at that time by the founder to focus the company resources on establishing a nationwide network of terminals and contracting out the deliveries.
I don't think anyone disputes that it's favorable to FedEx to have this model.
Yeah, and if you couldn't do it this way, if you couldn't get somebody to take responsibility to provide trucks, to provide truck maintenance, to figure out how to run the route without a lot of supervisors that we didn't have and didn't want, that you could not get into this business any other way. And today, it'd probably be the deal, you could call UPS or you could call UPS. And so this is valuable to the public. I think the ATA brief does a great job of indicating that you should not deny people who want to be independent contractors the opportunity to enter into these contracts.
Now we're talking about public policy.
Yes.
Before we go there, I'd like to ask about a couple of things that your opponent said when he was before us. He identified 3 areas as sources of control: regulation, external regulation, and I think he's given that up and said we agree with our opponent. If to the degree that the control is asserted because of external regulation, we're not arguing about that. But he also talked about customer expectations and then business results. So my question for you is, to the extent you agree with that formulation of what are identified as the sources of control, can't customer expectations and business results justify any kind of control over a worker? And I mean, isn't that kind of an infinity and beyond sort of situation that a person in your position can always argue, well, those justify this and it has nothing to do with whether we're controlling the employee. These are external to us somehow.
Well, I think you
seems so elastic to me.
correctly indicated before that there's no magic formula and the facts depend on each case.
I'm interested in your answer to that question too.
And in this case, you know, what controls you impose, there is a limited universe, but there's obviously some reasonable expectations that customers have for package delivery businesses, for other businesses. I mean, I just had somebody on my premises, my home, as doing contracting work, and the painter wants to start at 7 in the morning. I can say, no, don't come at 7 in the morning. I'm not going to have you paint in the living room while I'm trying to get ready for work. And so there are reasonable boundaries that customers have for when packages can be delivered. And some contractors, it does affect individual pickups, but not their whole life. Not their whole life. And it's something that, and the scanners and the way results are reported, that's the other big deal to them. Well, the purpose of a scanner is when you're treating that customer as your own, you can use that scanner to report instantly, and it goes instantly, to a website where you, as the customer, it's your package that you ordered and you wanted it and you want to know where it is. It's reported instantly to them.
But
FedEx Ground doesn't continually monitor that. It doesn't watch these employees all during the day. These customer service rides and whatever happen like 2% of their time. It's way different than employees who are subject to supervision all the time.
But doesn't it give them the ability to audit what the contractor has done during the day and use that as part of the review process?
Well, we don't review means and methods. The federal district court found we have only the right to make suggestions, and that this contract means what it says.
That's two different things, what you review and whether you can force it. The ways and means on the ride-alongs, the way I understood it, the sheets that are provided to the managers or the evaluators talk about the odometer readings and the length of time in between stops and how they get in and out of the truck, how they unload packages, whether they are resetting their scanner for the next stop as they're walking back from that delivery. To me, that sounds like ways and means.
It's observing some of the means and providing helpful ideas about how to be more efficient.
And it's documented. It's documented, and they call it a recommendation, they have a meeting, but they can use that to terminate.
No, I would disagree with that. I think the
At the
district
end
court
of
found...
the year, at the end of the year, they can terminate they don't have to renew the contract, FedEx. They don't have to have cause not to renew the contract at the end of the year.
That's true.
So de facto, if they don't like, he can drive any way or she can drive any way they want to in between stops, but if it's inefficient, according to their ride-alongs, then they just don't renew. And to me, if you lose your job for not following the company's recommendations for efficient operation of the ways and means, that's not really a recommendation. It's our way or the highway.
Okay, I am not aware of any evidence to support that conclusion. I think the district court looked at the evidence and found that there was no evidence of arbitrary terminations or keeping track of those for purposes of implementing terminations.
We're talking about the right to control by the agreements, and according to the operating agreement, it does not have to be renewed.
For any reason or no reason, and not considering those reasons, there's no evidence that we do that as a means of procuring controlled means and methods. In fact, the policies say we can't, the contract says we can't. Our managers are subject to discipline if they try to control the means and methods of the contractors.
Let me give you an opportunity to ask some other questions I have on illusory provisions. You assert these are independent contractors because they can use the truck to do other jobs. But they're assigned packages that one would expect to take 9 to 11 hours to deliver. And then after that, they would have to cover up the truck and make certain that they didn't violate Department of Transportation regulations on how long they can drive a vehicle in a day. So as a practical matter, it doesn't seem to me that they really do have the opportunity. they have the right, contractual right, but the logistical, practical right. You understand what I'm saying?
I do understand what you're saying, and, you know, the court, this class was certified on the basis of actual right to control, a right to control, not the actual exercise thereof. And when you start speculating about, well, they can't do it, or they could do it on weekends, I mean, and they could do it with allowing someone else to drive it. They have the right to use it for other commercial purposes, and some do. There's no evidence that nobody does that. Some do. So the right exists, and that was the basis for determining the question.
You spoke early on about the mutual benefits that are derived from the operating agreement to both the driver and the FedEx, and that's one of the things we should look at. But when you look at how it's set up, really the means by which those benefits, those mutual benefits are derived, are controlled by one party, that being your client. And I'd like you to speak to that. What controls do the drivers have over the conditions in the operating agreement? It just seems to me there are very few. And it's so one-sided, at least as I look at it, in terms of what is actually derived from.
Okay. Well, let me try to outline that for you. Of course, we've mentioned that they can decide whether to hire others, assistants, helpers, replacements, substitutes to take more time off.
And
they can decide how to...
And again, that is controlled by your client, who basically has to approve that.
The only ground on which we can disapprove it is that the other driver isn't qualified under lawful regulations, and to presume there's no such thing as good faith and fair dealing, and that you can't have contracts that have approval and consent requirements based on minimal objective factors related to legal requirements, is just, that's the mistaken thought, I think. This happens in many contexts, and I've won some lawsuits on them. You can read one, Bonanza versus McLean, 242 Kansas 209. And so... Yeah. Thank you. Yes. That is a while ago. It's still good law. You've cited it a lot. You liked it. So let me go on with what they can do. They have the decision to buy vehicles, to lease, or to purchase, new or used. They can do their own maintenance. Some of them decide to do that. They decide how packages are loaded, in what order to deliver. They can trade packages with other contractors and change for the purpose of efficiency and altering their times of day. They decide whether to renew or sell or acquire routes. They can market to customers. They decide their legal and business structure. They can be incorporated. They can organize an LLC, and many of them, or most of them probably do. They make decisions about insurance coverage. They have decisions about how they control their costs. And frankly, we'd rather have people who are good business people as contractors. And as you can see, when you have multiple work area contractors, we think that proves the rule that this contract does give people legitimate economic freedom and business opportunity.
Counsel, so should we be focusing on what the contract says or what is done under the contract?
If you focus on what is done under the contract, you will be violating the class certification order, which said we stipulate, because this case was one of numerous cases consolidated in the MDL where they had a lot of difficult decisions over class certification. And wherever you looked at what was actually done and where you applied economic realities tests, the court found that individual considerations, individualized issues predominated and the classes could not be certified. This class is created on this constrained record because of the narrow class certification order and the stipulation of the plaintiffs at that time that we won't go outside of this. And I really would encourage...
Isn't that a little contradictory when you say, no, you have to apply good faith, fair dealing covenant to the interpretation, and you're asking us to look at the operating agreement and decide that FedEx can be unfair by the agreement, but go outside that to a implied covenant?
The purpose I'm advancing the implied covenant for is that you can't presume these clauses are illusory because the law gives them meaning. They limit your right to be arbitrary. They require you to look at arbitrary facts and have a real grounds to say no. So it's inherent in the contract that you can't exercise these consent provisions arbitrarily, and you have to assume that they will be exercised in accordance with the law. So that's a legal point, in my view.
Counsel, you're well out of time as well. Would you like 30 seconds to wrap up?
Yeah, I'd like another 20 minutes to wrap up, frankly, because this is a hard, you know, it's a good case, and I want you to get it right when they send it to Kansas. I just want to mention that the KWPA, when you look back at what that was enacted to do, they were talking about employers who skipped town without paying, who falsely accused employees of taking bad checks, cash drawer shortages, not catching shoplifters. It was young people. It was Senator Perry said the main thing that's wrong with our existing law is it doesn't protect people from, quote, dishonest employers, end quote. There was no consideration whatsoever of independent contracting or attempting to redefine or correct what's going on that's wrong in the independent contracting world, and this statute was not designed to change that definition. It should be applied like the conventional rule that when a party brings a case as a plaintiff for a statutory remedy, they have to bring themselves within the protection of the statute, and then it's liberally construed.
One of the examples was deducting the employer's expenses from the employee's wages, if I remember correctly, of the ills intended to be cured. And that's really what the allegation is here, is that FedEx shifted its operating expenses to the employee.
Well, but this case also is bifurcated, so there's no real evidence on that. I mean, there are a lot of things like where some employees elect to have it, like they get a fuel credit card that goes through the company and they have that deducted. Others pay cash, others pay out of their pocket, and there's going to be all kinds of issues over that if this is a class.
My point is, the allegation is one that fits within the ambit of the KWPA.
If you're an employee.
Exactly.
Yeah. But there's no rule of broad construction. That's limited strictly to the Workers' Comp Act. And there's no cross-reference, no discussion, no section that's copied from the Workers' Comp Act. Thank you.
Before you sit down, counsel, let me ask my colleagues if we have any more questions for you. Any for? All right, thank you, counsel. Reserve 3 minutes for rebuttal.
May it please the court. Judge Kreitz, the test is what is done under the contract. In the Noble case, the court looked at that and said, of course, if the party's contractual labels control, then you're not going to have any employees. You can create any meaningless labels you want. So the test in Kansas is what is done under the contract. And it doesn't
about
violate...
counsel's argument that that's going to ruin the certification.
The district court found that the certification will be based on the common evidence in the operating agreement, the common corporate policies and procedures that apply to everybody, and the common training and guidance and management that FedEx employs. That's looking at what these common documents retain control over. So it is a different issue.
If that's true, should we reformulate the question and just clarify our case law for the Seventh Circuit and leave it to them to apply, to make the determination that there really are no disputed facts?
Well, I mean, not to be flip, you can do whatever you want, but what the Seventh Circuit and what the district court are trying to do is to put themselves in your chairs and decide the case based on these facts. I respectfully suggest that you have a better shot at that than them guessing what you do.
But if we look at how the contracts have been applied, aren't we getting into the realm of factual, or what might be disputed facts? It doesn't sound to me like the two of you have agreed necessarily on that.
Well, whether Mr. Oliver and I agree is frankly immaterial. In the district court's opinion, the Seventh Circuit directs you to the facts that it says control this case, and I think that are set out in a fairly straightforward basis. Now, the conclusions, the district court says A, B, and C equals F, you have to take A, B, and C as the facts, which are clearly set forth, and then come to your own conclusion.
You don't think there are any additional facts we would need to have to do that?
I don't think so. This was submitted to the court on a summary judgment because the parties felt like the facts necessary for resolution were there.
Do I understand you to say that when the district court said that I am going to consider policies and procedures outside the operating agreement, that encompassed what was being done under the agreement? In other words, the
Yes.
policy and procedures set forth the what is being done without additional facts. Is that
Yes.
what you're saying?
Yes.
Okay.
And to answer your question on termination, you don't have to wait till the end of the year. They do all this auditing of whether the driver is doing what they were taught in the quality pickup and delivery learning at the beginning of the case, and the beginning of their employment, and that auditing and supervision checks whether they're still doing it. If they're not, it goes into their driver file. They can have business discussion meetings, goes into their permanent file, and FedEx retains the right to terminate them, not at the end of the year when they don't renew. They can do that as well. But they retain the right to terminate them for improper scanner use, customer complaints, failing to service an area, any broad number of things that are included in this expansive operating agreement.
Let's talk about basic fairness. These drivers signed up for this circumstance, and they get to own their own truck, and at least theoretically, they get to make more money than the pure employee. Why do they get to cherry pick and take the benefits of employees that they want, but retain the benefits of an independent contractor also? Do you understand what I'm asking you?
I understand what you're asking, and I think the answer is that this is a uniform contract presented to all the drivers. The Wage Payment Act is specifically designed to present shifting these costs over to the workers. So by drafting that agreement and just basing it on what the contract says, isn't looking at what's done under the discussion we just had about what actually occurs, which is what the test is that this court has used for decades. And the idea that the items in there are simply suggestions to be followed.
No, I understand all that, but Mr. Craig or Ms. Craig, whichever, could have gone to work for UPS, could have gone to work for the Postal Service, but that driver chose to enter into this agreement and did so voluntarily. And so why shouldn't we say, you did this voluntarily, live with it? This is your agreement.
Because that's not the test under the right of control test to see whether someone's an employee or independent contractor. The intent of the parties can be a factor that is used to answer the question of whether the employer has maintained the right of control over the means and manner of the work. Just like is the employee's work integrated into the work of the principal. There's any number of factors described in the restatement or in some of the court's cases where you use those factors, and intent of the parties could be one, but it's not the paramount one that this court has identified. It was mentioned that packages are only given to another driver if they determine they cannot serve. I mean, here's how it works. FedEx Home, this isn't the overnight package delivery FedEx Express. It has to be there tomorrow. That's employees do that. This is FedEx Ground and Home Delivery. Home delivery, zip code routes, no discretion to turn down work. I tell you what your daily work is, you have no discretion to turn it down. I mean, what independent contractor can't take a pass on an opportunity? And that includes packages in the route, in the zip code, and maybe packages all the way across on the other side of Pittsburgh to be delivered. FedEx tells them to do that. The ground drivers, no discretion once they opt in at the very first time they sign up to the Flex program, renews automatically after that. No discretion to turn down work. I decide what packages go into your route and out of your route, and your pay, which isn't negotiated, which is unilaterally determined by FedEx, which is set under FedEx formula. The majority component of it is the piece rate and the stop rate. How many packages do I give you? How many stops do I give you? All unilaterally controlled by FedEx, subject to their unilateral change.
Counsel, you also are well out of time. Would you like 30 seconds to wrap up and then stand for questions?
Does anybody ever turn that down?
Mr. Oliver wanted 20 minutes. So.
This court can decide the case based on the right of control factors, I think found in the Noble case, also in the Wells case we provided in our supplemental authority, and the Estrada case, two cases interpreting this same operating agreement. I think you'll find them helpful and persuasive as you evaluate some of these same criteria. So you can decide it without the public policy, but the public policy embedded in this act that this court has described in the Campbell and Coma cases, I think has to inform the court that you can't let any old document that describes, in this detailed language, certain illusory rights that mask the employment relationship.
I don't understand how Estrada is persuasive to us if you discount public policy, because that was a specific California statute, and we have a specific Kansas statute. The only way that really is persuasive is the language in there about public policy.
Well, Estrada was decided under the the California equivalent of the Wage Payment Act. It didn't have a definition of employee, but it didn't apply a public policy. It looked at the operating agreement, and I'd suggest to you that without applying and reaching public policy, you can decide this case. You can save that for another day where it's fully briefed up through the courts of Kansas. But, you've discussed it, it's out there, and we'd ask that the expansive definition of employee and that policy be considered as the court makes its evaluation.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. Now